Recording in progress.
All right, chapter 20, transfer of title. In this, title meaning ownership, so transfer of ownership. Let's translate everything in our heads, get in the habit of doing that so that we could understand what we're talking about as we learn the new lingo. Transfer of title. Title means ownership,
What
transfer of ownership.
what page are you on?
Chapter 20. So just I don't know what page it is. Let's take a look and see. Chapter 20, you are going to be on page number 373.
373.
Mhm. So, in this chapter, we're going to describe 4 methods of title transfer, and we're going to explain the process of the transfer of title of a deceased person's property, how that works. We're also going to discuss who can inherit and what are the requirements to have a valid will and all that jazz. So let's start off with this slide right here on page 373. We could do the highlights and we could do this little definition that alienation is the transfer of title to a parcel of real estate. And we're highlighting also that title to real estate means the right to or ownership of the land. So alienation is the transfer of title to a parcel of real estate, and that can be done during a lifetime or after one's death. It could be voluntarily, something that you wanted, or involuntarily, something you did not want. At death, voluntary alienation is through a will, or involuntary alienation is if there is no will left, the state will get the property through the process of escheat if no heirs step forward to claim it. The property will sell at an auction, and the whole money will be held in a fund for a year, at which time those heirs can step forward to claim ownership of it. Otherwise, the state gets your money. So make a will so the state don't get your money or your stuff, right? So alienation of title. Alienation is a transfer of property, so alienation of ownership of real estate. If it's done voluntary alienation of title can be done by gift, sale, or exchange. You could give your property away, you could sell it, or exchange it. Owners, owner or owners use some form of deed to convey that ownership during their lifetime. A deed is only valid while you're alive. So deeds only convey ownership interest or any interest in real property if it's transferred while you're alive. Remember that transfer takes place upon delivery and acceptance of the deed itself. Even if you filled out the deed, you signed it, but you didn't get a chance to deliver it and the other person didn't accept it, the transfer did not take place. Okay. So then it would go according to your will. Will is the transfer, the voluntary transfer of property upon your death. So wills are valid after you die. Deeds are used to transfer property while you're alive. Transfer of ownership or to or from the government is done by dedication or public grant. Dedication is giving land to the government for a public use like streets, schools, and parks. Whereas public grant is where the government may give you, a private citizen, the real estate. It works the other way around. Okay. So
Did you explain already when the government gives a public land to an individual for private use?
no, I didn't talk about it at all.
Okay.
Because
I
I
thought that
mean,
was the example.
I, well, those are examples, but I didn't give you an example of when that happens. I mean, uh, I don't know. Dedication is usually when you give land to the government for a public use. Let's just say
Free
you
of
have a piece of,
cost?
I'm sorry.
Free of cost?
Yeah.
Like donating to the government?
Yep. Yep.
Okay.
Um, you have a piece of property as an example. and then you subdivide it, and you build 6 houses and you sell those houses, but you had to put a street on the property. It's on your property, a street you paved. Do you want to be responsible after you sell all those houses to maintain that street forever? You're not getting income to maintain it. So you got your money, you sold the houses on there, dedicate the street. You could name the street and then dedicate it to the city. And then it'll be a city street that they're responsible for plowing the snow or repaving as it breaks down, etc. Right? You don't want to keep that responsibility. So you would dedicate that land to the government. So that's one example of where you would give land to the government. Or maybe you want to dedicate an area for a park, or for a school. Sometimes it's required in order to get a permit from a city to build whatever project you want to build. A developer may be required to build a school. Hey, you're building this, you want us to give you approval to build this high rise. It's going to put hundreds of families. That's additional school. We don't got that space in our schools. We want you to build we want you to build a school as well if you want the approval for all this housing. So you need to dedicate land for the school, or you need to build the school. That's just another example of dedication. Public grant, maybe the city has a corner lot at the edge, at the end of the property. You got a corner property, but just past the corner, there's a grassy area. And the city rarely comes to mow the lawn, if ever. So you took it on to do it, and you've been mowing that grass for years. Because you've been using it, can you take publicly owned property through adverse possession? The answer is no. Privately owned property can be taken by someone else by adverse possession, but not government owned property or publicly owned property. But you could go and ask the town, say, hey, listen, I've been cutting the grass here forever. You guys never maintain it. I'm going to stop maintaining it. You guys are going to need to come here and start cutting the grass on a regular basis. It's just a little bit of a corner lot, unless you want to give it to me. And now it'll be mine, and that's some additional taxes I'll be paying for having a bigger lot. Okay? So you either start maintaining this property that you can't do squat with, or you could give it to me and then charge me tax dollars for having a bigger lot. Okay? That's where it would make sense for a public grant. But, I've seen some crooked politicians do some stuff too. Like in my town, my mayor, he's given lots of land where people put 2-family houses on them. Where just around the corner, he told me I can't convert my house to a 2-family, where I had a house right over there. A crooked mayor there. But anyway, it's up to those in charge, right? Who are making those decisions. Okay, so let's do some highlights now for voluntary alienation, involuntary alienation, what dedication and public grant is. And then it says here, when a person dies intestate and leaves no heirs, the title to their real estate passes to the state by escheat. So you may want to make a little notation of that as well. Escheat. Okay, and okay. Okay, so you guys could do that. And I forgot my cell phone downstairs, which I need that for my time. So as you guys take these notes, I will be right back as I take a quick run to go get it. All right, so hang tight. I'll be right back. Let me pause the recording in the meantime while you guys do these notes. So everybody's got these notes, right? The highlights? Good? Cheers. All right. So Alienation, involuntary alienation, is a transfer without the owner's consent by escheat, eminent domain. It could be done through unpaid debts like taxes and mortgage loans. You could get foreclosed. It could be by court action through a partition proceeding or a suit to quiet title. It could be done by adverse possession through what's known as an easement by prescription. To perfect this, you have to sue the other party, though. It's called a suit for adverse possession, or sometimes a suit to quiet title for the judge to order one person's favor as being the owner. And it can be done by erosion by Mother Nature to decrease the land by the wearing away of wind, by wind or water. And then we should highlight here on page 375 on the second paragraph, in a partition proceeding, one co-owner seeks to force another to divide or sell the property. So a judge will see if a property can be partitioned physically, and if that's not possible, they're going to order the sale of the property to partition it, and you will then each party will get their shares of the proceeds from that sale. So here's some examples of involuntary alienation as well. In this, a person dies intestate, has no heirs. The property will, through the process of escheat, revert to the state. If land is needed for a public use, through eminent domain and payment for the property, if with just compensation, if a property is needed for a greater public good, a public or quasi-governmental agency could take that property. So can utilities. Non-payment of a debt secured by real property. Through the process of foreclosure, the sheriff sells it at auction and it gets sold to the highest bidder. And through the open, notorious, continuous, hostile, and adverse use of another person's property for a prescribed period of time as defined by state law, through the process of adverse possession and what we call easement by prescription, an adverse possessor can take ownership of the property that they've been using against your permission for a period of time as prescribed by state law. So we already got this highlight down, right? Land could be transferred without an owner's consent to satisfy debts contracted by the owner. In such cases, the debt is foreclosed, the property sold, and the proceeds of the sale are applied to pay off the debt. That's what the purpose of foreclosure is. Debts can be foreclosed, including mortgage loans. In New Jersey, foreclosure is a judicial process. It has to go through the court systems. Some states have non-judicial foreclosure. New Jersey has judicial foreclosure, which has to go through the courts. So this would include mortgage loans, real estate taxes, construction liens for unpaid work that a contractor did on your property, or general judgments against the property owner can be turned into liens against the property. All right. So here's what an easement by prescription is. These are pretty good notes for you to just highlight it or snap a picture of this slide. I'm sorry. Now, you know what? Before we even go through with this, let me take a look at my slideshow for a second. Sorry, I'm off screen. I'm just eating an ice pop, and I don't want to do that in front of you and tease you. So let me see if I added to this slideshow. No, I did not, but I do have a quick little video to show you about adverse possession. Or should I be showing that just yet? Maybe I'll save that towards chapter 7. No, I'll show it to you now. Hold on, let me just pull it out. It's a new video from this lawyer. She does a pretty good job. So I like showing them. Okay, well, I didn't download that one yet, so let me look at my notes to pull out that video from her. And I have something else I will show you as well. Just give me 1 second while I look it up.
Recording in progress.
All right, guys. So we got this real estate attorney here who's going to show you a little bit about, talk a little bit about adverse possession. But first, she's got this video, a couple of short videos that I downloaded from her YouTube page. Let's take a look at them for the first time together.
I always wondered if you can petition a judge to grant you a property that's been abandoned.
So that there is a mechanism to go to court and ask for a property to be declared yours. It's called a quiet title action, but you need to have some rights in the property. You know, in my experience, if you are someone who just saw a property and you're like, I want that property, but I have no way to acquire it, highly unlikely that you're going to petition, file your quiet title action and be able to demonstrate that you are in fact the rightful owner of the property. To answer the question, can I petition a judge? Meaning, can I file a lawsuit in North Carolina to establish that a property is mine?
Or anywhere.
Yes. Will you be successful on those facts? I have no idea.
Always wondered if you can petition.
So, okay, well, that was a real short. I guess that's a super short. That one was, I guess she got down to the, can you file a lawsuit? Yes. Well, you get it? No. She has no idea. All right, let's see the other one. Let me look at the other one really quick, see if this is of any value.
Thing called squatters' rights.
So imagine this, you rent out your guest house to make a little extra money, but 2 years later that guest has not left, also hasn't paid rent for a significant amount of months. Wow. Well, that's the reality for a doctor in Los Angeles.
First, you need to understand what is adverse possession. And this is property that you didn't own to start with. So this would mean, somebody else's property, you never paid for it, you didn't buy it, but you have occupied it in a certain way for a certain amount of time that you may end up with rights to it. A lot of times this happens with farmland because the boundaries of their property meandered and it's expansive land, so they're not monitoring the boundaries of their property to make sure nobody is sliding over in it. We've all heard those unsettling stories about someone.
This part gives you a good explanation with a visual about how you could have that ownership creep where the property boundary moves in farmland. Okay, that was an extremely short video right there. There's one that she has here that gives you a bigger, longer explanation. And I have another one from an attorney that specializes in this stuff too, that she gives you all the legal stuff from an attorney's perspective, talking to other attorneys. But that's going to be in chapter 7. But let's look. Yeah. Okay, this one is the longer video. It started out the same way. I just wanted to make sure that it was an actual video on it. Okay, so here we go. Let's watch this one.
We've all heard those unsettling stories about someone losing their property because of something called squatters' rights. And what they're probably referring to as squatters' rights is someone acquiring property through the means of adverse possession. I'm Tiffany Weber, a North Carolina real estate attorney, and while adverse possession is rare, I have seen it and I've had court cases on it. So I'm going to talk you through what adverse possession means and how you may be able to protect yourself against it. First, you need to understand what is adverse possession. And this is property that you didn't own to start with. So this would mean, somebody else's property, you never paid for it, you didn't buy it, but you have occupied it in a certain way for a certain amount of time that you may end up with rights to it. A lot of times this happens with farmland because the boundaries of their property meandered and didn't have it constantly being surveyed. It's expansive land, so they're not monitoring the boundaries of their property to make sure nobody is sliding over in it. So that's kind of how this happened. Now, it's important to know that adverse possession doesn't just automatically happen once you reach a certain milestone. This is something that has to be litigated in court to establish. At least in North Carolina, you'd have to do some sort of quiet title action or a declaratory judgment in which a judge would say, yep, you've met all these elements, this
In
property
New Jersey
is yours
too.
now. So since I'm going on and on about the elements, what are they? The acronym that we used in law school to remember these elements is so silly, but it's a horse on every corner. So A stands for adverse, obviously, because it's adverse possession. But that means contrary to the true owner's possession. So adverse and hostile are really similar. Hostile doesn't mean, that would be the second one, so the H, the horse. Hostility doesn't mean arguing. It doesn't mean fighting. It just means contrary. So I own property. You start to, encroach on my property and use it as your own. Well, that's hostile to my ownership. And it also has to be without permission. So I don't want you there, but you're doing it anyway. The next thing, a horse on, the on actually is O and N. So we kind of combine those, open and notorious. So meaning you can't be secretly using the property. It's not like you go out there and you hide what you're doing and the owner can't know about it. Notorious meaning that really anybody could see you're doing it. There's nothing quiet about it. You're just out there using the property as if it's your own. All it would take is somebody paying attention, halfway paying attention to see that you're using the property as your own. So again, you're not going to get adverse possession by sneaking around and secretly using the property in a way that wouldn't put the owner on notice. Next thing, a horse on every corner. So the E is exclusive, meaning nobody else is using it with you. You're using it for yourself. The owner's, actually not using the property with you. It's not like a whole bunch of people are doing the same thing. If you've got 100 people that are using a roadway on a property, but then you try to claim adverse possession and you're just one of 100 people doing that, that's not exclusivity. And then finally, the corner part of a horse on every corner is continuous. So continuous and uninterrupted. Now this one can be kind of confusing if you read the case law, because continuous and uninterrupted doesn't necessarily mean that you are using the property 24/7, 365. It's not like you just have to be parked out on the property, never leaving, etc. This is a pattern of use that it's not like, you go out there for 1 week a year and then you don't come back for 3 years and then you're there for 2 weeks. It means predictability. It means that there is some routine to how you're using this property. And the other thing about this adverse possession claim is that your intent has to be that you're trying to own the property. You're claiming it as yours, even though it's not. So that's kind of the adverse and hostility thing, is you're saying, no, this is my property. And you don't have permission, you're doing so without permission of the true owner. And you're basically treating it as if it's your own, and you're doing so for that limited time. So if you don't ever have the intention to claim the property as your own, and you've got the permission to do it, you're not actually doing it contrary to the true owner's interest, then you're not going to be able to meet those elements. So intent is a really big part of proving adverse possession. So if you're a property owner hearing this, like, how do I keep myself from, having somebody take over my property because they've been using it? Well, one is pay attention to who's using your property. If you are, if you're someone that owns a big tract of land, then, 20 years is a long time for the most common type of adverse possession, though it's not that common. So that's a lot of time for you to go out there and check your property out to make sure that people are not using it contrary to your interest. So that would be number one, is paying attention to the property and who's using it. Another thing is you have to be very careful about saying you don't have permission to do this, because once you say no permission allowed, then that time could start ticking. So if you have someone using your property and you told them they can't do it, before you make any sort of communication to that other party, consult with a real estate litigation attorney first. Not me, I don't do litigation, but there are plenty of really good ones in your area. Consult with them first before you make communications, because you may be inadvertently triggering one of the elements of adverse possession that wouldn't have otherwise been met. But it means you do have to actually be paying attention to your property, who's using it, and making sure that nobody's using your property without your permission. So lots of stuff to go into on adverse possession. Hopefully you learned something about adverse possession and what it actually takes to have someone take over your property without your permission.
All right, so that's a basic explanation of adverse possession and how it works. Let's look at she gave the pretty good explanation of the details. Let's go over them for New Jersey specifically and get into some of the details of it. So for adverse possession, also known as an easement by prescription, this is a type of easement. Some people refer to it as squatter's right or adverse possession. It's when you use someone else's property for a period of time as defined by state law. You could claim ownership of that property that is being used. Now, to perfect this type of an easement by prescription, it does require a court action called a suit for adverse possession, or a suit to quiet title, for the judge basically to rule in one party's favor over the other as to who's the owner, in order to claim ownership of that land. Now, the use must be continuous, hostile, adverse to the owner's title, exclusive, and without the owner's approval. If you get the owner's approval, you can't claim ownership of the property because they gave you permission to use it. This has to be against their permission in order for you to claim that ownership. Additionally, the use must be out in the open, visible. You can't be using the property secretively. It has to be obvious that you're using it. Open and notorious. You're using it out in the open. It's visible, open, and notorious that you're using someone else's property against their permission. Once again, it's very important. It needs to be against their permission. Hostile and adverse to their title. That's what hostile means. It means against their permission. Continuous usage, like it was said in this previous video I showed you, that the continuous use has to have some sort of a pattern that you've been using it for a period of time. It's not that you're constantly using it and never leaving the property. Okay. And you're exclusively using it. You're not using it with others, or like I said, if there's an easement where there's a roadway where hundreds of people have been using it, and then you're the one person that's going to try to claim ownership of it, that won't fly. It has to be you exclusively using that property for your purposes to claim ownership. Now, the prescriptive period of time that is needed to perfect the claim of adverse possession in New Jersey is currently 30 years for improved lands and 60 years for unimproved woodlands. It's for wetlands or woodlands. 30 years for improved lands, that there's a man-made improvement on it of some sort, in order to perfect these claims. Now, the law will change at some point in the future to 20 years, which is the common law period in New Jersey. But until that happens, which It's been about 17 or 18 years that I've been following it. There's been a conflict in the law. Somebody tried suing to claim adverse possession on a property. And in a judge, instead of making a decision in one party's favor or not, they actually found out that there are conflicting laws. Our politicians in New Jersey made too many laws on this topic. You have one law that's for 30 years, another one for 60 years, and there's the common law 20-year period, which says that once somebody's reached 20 years, they've got to file the court suit for adverse possession to make the claim. But in New Jersey, they wouldn't win it because our politicians made too many laws. They also added a 30-year law for improved lands and 60 years for unimproved lands. So they added more laws without removing the other ones. So now there's a conflict in the law. So if that judge ruled in one party's favor, they would be what we call legislating from the bench, creating a precedent or creating a de facto law by making a ruling. And that's not the judge's job. The judge's job is to rule based on the laws that are written. And if there's a conflict in the laws, they're supposed to throw it out of court, back to the politicians to fix the conflict that they made by making too many laws covering the same topic. You know, we know that when judges rule from the bench and make decisions, it could create all kinds of problems. Just to get off topic slightly, it's not off topic because it's talking about the judges and how they rule and make their decisions. We recently, a year or two ago, it was where the Supreme Court actually heard a case about the Roe versus Wade decision. We all heard about this in the media. You know, they were like, all these judges, you know, they reversed long-standing law that made abortions illegal. Okay, that's what the Roe versus Wade case was about. And there was actually no law. This is why the Supreme Court agreed to hear this, because for the first time in 50 years, somebody actually took it to court, and the Supreme Court agreed to take it up and listen to it. And they said, yes, a judge, one man, a single judge made a ruling based on a lady who claimed that she was raped so that she could have an abortion. And the judge felt for her and he ruled in her favor and allowed her to have it. So then that became the law of the land because the judge made a ruling. So everybody else in every other state followed the precedent that was set by this one ruling. But it was a precedent that's kind of like the president making an executive order instead of Congress making a law. Laws stand and they're hard to undo. If you got a president that just makes an executive order, the next guy that comes in can undo it, you know. So a judge making a decision did not make a law. He just made a precedent that others could follow, and they chose to for 50 years until it got heard by the Supreme Court and they struck it down. They said, yeah, the judge had no right to do this. So they kicked it out. They didn't make abortion's illegal. They just said each state now has to create their own legislation on it, or Congress, if they want to make it the law of the land, Congress has to rule on it. And somebody needs to propose a law and make one. See, that's the funny thing. You see a lot of hypocritical lawmakers. They say, oh, yes, we're all for this. We're all for this. Okay, well, then put your money where your mouth is, create a law, put it before Congress, vote on it, and make a law. See, politicians love to make a lot of noise, but when it comes to action and them actually doing something, they cower because it could take votes away from them on hot button topics like abortion, for example. But that's just going over what that case was. Oh, and another little factoid about that one, that initial case, Roe versus Wade, if you guys don't know the details of it, that lady that claimed that she was raped and had to have and for the reason of wanting to have the abortion, it was a lie, and she admitted it years later. But the advocates for it never agreed to that. They never backed down. They say, "Oh, this is for this reason. You know, the case was originally passed because of this." Yes, but it was all based on a lie anyway, and it was never based on legislation that a politician put forward and was voted on. That's why it was able to be undone, making up my own words, undone in court by the Supreme Court. And then it went down to each state to create their own laws. Now, in such a fashion here, New Jersey, our politicians created too many laws. If you create too many laws and they are in conflict with each other, judge can't rule on those. Well, they could, but if they did, it could always be overturned later. So this judge made the right decision, kicked it back to New Jersey legislators. They decided that they're going to do away with the 30-year and the 60-year period and go with the 20-year common law. However, they still have not done it. It's sitting on their docket to vote on. They're all in agreement that they want to do this. All they got to do is put it up for a vote. They haven't done it. 18 years later, it's still sitting on the New Jersey legislature docket. Look it up yourselves. Sitting there for 18 years. If they want a new gas tax, boom, they pass it like that. But to clear up conflicts that they made, their own problems, sitting there for 18 years. All right, moving along. But what do we need to know? You need to know for exams, because they'll ask you, what is the prescriptive period in New Jersey? You need to know 30 years for improved lands, 60 years for unimproved lands. Don't worry about the 20-year common law period. That's not in the exam questions, okay? But it is on the books and it is a law. Now, through the process of tacking, successors in interest, like a landlord and a tenant, an ancestor and an heir, or seller and a buyer, they could add one person's time of use onto another's to reach that prescriptive period of time that's required to get adverse possession. Okay? So it's not like one person has to continuously use it. Say that my father was squatting on someone's property and continuously using it for 25 years. But he died and I remained there, took over using it. So he could pass on his possession to me, and I just need to be there for 5 more years before I could file the suit for adverse possession to perfect that claim of an easement by prescription. Okay, and then take over the ownership and actually file a court case and perfect the easement and become the true owner. This court action is required for perfecting an easement by prescription to claim ownership. It does have to go through the courts. It is not automatic that you become the owner because you've been using it for the prescribed period of time. You need to take it to court to claim that ownership as well. So how can a landowner prevent somebody from claiming the ownership? Well, there's 3 ways. An owner can take legal action against any adverse possessor to get them removed from the land. They could cut off their access to stop the continuous use. That would also reset the time clock on that adverse possession period, the prescribed period. Or they could give them permission. They could send them a certified letter in the mail, giving them permission, serving them documents, giving them permission to use the land. If they haven't started that adverse claim yet, well, you just reset the time clock. You not only reset the time clock, you gave them permission. And by giving permission to use the land, they cannot claim adverse possession against an owner who gave you permission to be on their property. You can't claim ownership of that property because they gave you permission. Everybody got that? So an easement by prescription cannot be claimed against publicly owned lands either, only against private property. You cannot claim an easement by prescription because you've got that corner lot and has a little extra grass, but that's a city lot. And the city's never been cutting it. You've been cutting that grass all the time. You cannot claim ownership of that lot because you've been cutting the grass for the last 30 or even 60 years. It's publicly owned land. You cannot claim ownership against publicly owned land. But you can go to the city and ask if they could give it to you. What do we call it when the government gives land to a private person? It's called public
grant.
I'm sorry.
Public grant.
It's called a public grant. When the government gives land to a private individual, they're granting the ownership that's owned by the public. So it's public grant of ownership. Correct. Okay. So there's everything we need to know about adverse possession and easements by prescription. Okay. And you will get that on exams. You need to know the different types of easements. So if you
And
haven't-
we also called the court action suit for quiet title.
a suit to quiet title.
Suit to quiet title. Do we have to remember that because I can't see that on the slide?
Well, on the slide here, I refer to it as a suit for adverse possession, but sometimes it could be referred to as a suit for quiet title or to quiet title.
Okay.
Basically, title means ownership. And if it's a lawsuit to quiet title, you want the judge, because there's some sort of an argument over the ownership. You want a judge to rule in one party's favor over the other to stop the noise that they're making. You want them to quiet title. As to making a definitive ruling as to who's the owner. That's what quiet title means. You want them to quiet the title. Okay. So we'll highlight this in the book on page 375 in chapter 20. Adverse possession is another means of involuntary transfer because this is against your permission, right? An owner may lose title to another person who has some claim on the land, takes possession, and most importantly, uses the land. So you should walk the boundaries of your property at least once every 30 years or 60 years if it's unimproved land, right? Otherwise, you may just lose it. In New Jersey, a person may acquire title by adverse possession through continuous, open, notorious, hostile, and exclusive occupation of another's property for 30 years for improved lands and 60 years if it's considered woodlands or wetlands. That's unimproved, no improvements on it. After that time, the user may perfect the claim of title to the land through the process known as adverse possession by bringing a court suit to quiet title. Okay. So through the process of tacking, those continuous periods of adverse possession may be combined by successive users, enabling a person who has not been in possession for the entire 30 years to establish a claim of adverse possession. And the process is not automatic, though. It must go through the court systems. Court action is necessary to perfect the claim. Adverse possession is not possible against publicly owned properties. Okay. Now, once it's gone through the court and an adverse user's established title that it's now their property, the former owner has no recourse. So to prevent such loss of title, everybody who's a property owner should walk the boundaries of their property and take action to remove any adverse possessors on their property. Look, it takes 30 years for improved land, 60 years for unimproved land. Even when the politicians do change the law to the 20-year common law period and get rid of the 30 and 60-year period, it's still 20 years that somebody's got to be using your property out in the open against your permission, ignoring you, and still using the property anyway. You should take action against them. And if you don't, well, you risk losing your property. Okay. Now, this is more common in farmland, but you could find it on city properties too. We're going to go back and we're going to go to chapter 7 after we're done with this chapter. I know we jumped ahead here to do chapter 20. We're going to go back to chapter 7, I believe it is, the one 6 or 7. I'm not sure.
6.
Chapter 6 is the chapter that goes over adverse possession. And I have a different attorney that gives you, like, she puts a report out like she's talking to another attorney. I just showed you a video from an attorney talking to the layperson who's new to this, explaining it. This one, she's explaining it to other attorneys, and I got a video that's pretty, her giving the formal explanation of how that happens, and it's pretty good explanation. We'll see there too. Okay, so let's just let me also make a note here about adverse possession.
Tacking is important for exams.
Well, you need to understand the term tacking. What does that mean? Where one user can add their time of use onto another's to reach the prescriptive period is known as tacking. Yes. So you could get a question like that on exams. Absolutely. You very well may. I know we got a question like that in our database of questions. State's got a database of questions too. You may get that one, you may not, but they got a database of thousands of questions. So, but I think it's very likely that you do. Yes. Adverse possession, tacking, and okay. How to avoid it. So I got in a bracket down here at the bottom, something that you're probably not going to get on an exam, but you may find it useful. I actually gave a mayor of a town some advice. What they were doing could end up costing the town a lot of money and ending up in lawsuits. I mentioned that in the conversation I was having with him as he was explaining to a group of people about what they're trying to do to make improvements and modernization to a town. He was talking about progress and all this stuff. And in the meantime, you got this one lady and her family owns a huge amount of land right in the middle of this municipality. And a lot of it is like old Victorian houses, and they're used for commercial purposes. It's a commercial park, and the mayor was talking about how they may restrict her use on how she could use the property so that they could kind of force her into selling it to a developer or modernizing it herself and building up the town, you know. And I told them you gotta be careful with that, because she could turn around and end up claiming what's known as inverse condemnation, and it could cost the city a lot of money. So what is that? Well, if a property owner feels that new government requirements have taken away their rights to use or develop their property, may seek damages under the concept of inverse condemnation, because all the red tape and restrictions that they put on the property owner, you could have that municipality may render that property useless to them, basically devaluing it without actually paying them for that. So the burden on the owner is on the owner to prove that governmental action has taken the property rights without compensation. But if they can prove it, that city's on the hook for paying them. That's called inverse condemnation. You're not going to get questions on the exam about this at all, but you may find it useful at some point. It's like a good thing to have in the toolbox to lock in the back of your mind there. Okay. Don't throw away these books after you get licensed. You may want to reference them maybe in the future sometime. What was that? I forget what it was called, but there was some way, you could look it up and then you could find it. Okay. All right. So easement by prescription, here's from chapter 6. Here's the definition in chapter 6. You don't need to turn back to chapter 6 right now. We'll do it when we go back to chapter 6. But these are the notes of the slightly different explanation of what an easement by prescription is in a different chapter in the same book. Okay. And that's because the people who are writing the book don't know. They don't realize that our New Jersey politicians created too many laws covering the same topic. So they're confused about it. I've spoken to the Real Estate Commission. They're even confused about it. They're not aware of this. I've been following this issue because of my OCD. I follow these issues in the legislative charter, and it's still sitting there waiting to be voted on. But look, the book claims that New Jersey's law is silent as to the required number of years in order to claim adverse possession. No, it's not. On the books, there's a 30-year period and a 60-year period, but there's also a 20-year period. There's a conflict, so nobody will win an adverse possession claim in New Jersey because of that. Now, an owner can halt the process by granting permission or by cutting off the continuous use or by taking legal action. So my slide has all of these things on there. So you don't need to highlight things at chapter 6 and chapter 11. You could get the full explanation on the slide that I've given you. All right, and you'll see it again if you didn't copy it. You'll have another chance to. Okay, so transfer of a deceased person's property. How does that work? Okay, let's look it up. Title, once again, just a word that means ownership. No document in real estate called title. Deed is the document used to transfer one's rights, title, or interest in a property, but it's not proof of ownership. A title needs to be transferred during one's lifetime because title is only valid while you're alive to transfer that ownership. A deed, deed. I said title. A deed is used to transfer the title while somebody's alive. Will, the last will and testament, is used to transfer your title, your interest in that property after you die. So the deed is the document used to transfer your interest in real property while you're alive, and your will is the document used to transfer the property after you die. And the transfer of property by will is known as devise. And devisee is the devisor is the one who's giving you their property by will. The devisee is the one who's receiving that property by a will. And testate means that you've prepared a will stating how you wish to dispose of your assets after your death. Remember, a will has no power until after you die. So can somebody write in their will that I'm going to leave you my house at 123 Main Street, and then during your lifetime you sell that house and don't update the will? Sure they can. Sure they can. I could write that I'm going to leave you my property in a will, and if I die, you get that property. But I'm still alive. I could sell the house and decide to move. I'm still alive.
I
But
thought
if
the devices.
if I sell that, okay, okay, you misunderstood what I was asking. Okay, if I sell that property while I'm still alive, and I didn't redo my will, but my will says you get 123 Main Street. If I no longer own 123 Main Street, you're not getting it because I sold it, right? I don't have the right to leave it to you. So you should update your wills if there's any major changes like that. After you write a will and you wrote something in a will, you should amend the wills or update them, or write a new one. Okay, just making that modification of what your new house is that you're going to leave to them. Okay. Now, transfer of title by descent takes effect when you die. Every state has their laws of descent distribution specifying who can inherit your assets upon your death when you die intestate. Why only when you die intestate? Because when you die testate, you're dictating who gets your stuff. This question is saying, who has the right to claim an inheritance from you? Well, if I decide that I wrote a will and I gave it to someone else, you don't get my stuff. But if you're a family member who has the right to inherit and I did not write a will, you can make a claim to get it. Okay, so the courts will have to determine if you have a rightful claim or not, and then whether they grant it to you or they don't. But to clear up any confusion like that, make a will. Make a will. So intestate means you did not prepare a will, and therefore any transfer of ownership to somebody would be involuntary because you're not the one who decided who gets it. Right? You understand that concept? Because you didn't write a will specifying who gets your stuff after you die, even if you are a natural heir and you could claim it, it's still involuntary alienation because you didn't specify who gets it. All right. So consult an attorney about making your will and your options. But I'm going to tell you a little bit about New Jersey law. What's required to make a will? We're going to get into that in just a moment. So let's first do the highlights about what intestate and what testate is. And here is that a will must be probated, meaning that all debts must be paid, especially any unpaid taxes or claims from creditors. You may want to write that in there. And probate or administration is a legal process by which a court determines who inherits the property of the deceased person and what the assets of their estate are after all debts have been paid. And remember these terms: an executor is a man who makes a will, an executrix is a woman who makes a will. It's a person named in a will to make sure that all your final wishes are carried out, the executor or executrix. Or if you don't name someone in your will, a court will name somebody to handle those duties, and they'll be called an administrator. Okay. Everybody good? Can I change the slide?
Yep.
All right. So once again, just like in chapter 5 slideshow, here chapter 20, we have that slide of death terms. By the way, during lunch hour, did anybody look up and claim property or missing money and look up your name and your relatives, or did you guys forget to? Anybody look at it yet? Anybody find it?
I plan to do it after school. I was doing some other work, but
All right. Don't forget to. I'm telling you, we usually have at least one person in class that finds something, and then share it with the class. Let us know what you found. You know, you don't got to split it with us. You know, just let us know if you found something.
I'm new to the country, so I'm sure there is nothing for me.
You never know. You may have bought something, or maybe your relatives did. Maybe it was a bank account and the bank shut down or sold, and then they transferred the funds somewhere. You never know. Or maybe you had a long lost relative that was here and they died and they left some assets that could be claimed, that have gone unclaimed. If that's the case and you're a rightful heir, you could claim those assets. Okay? You never know. You never know. All right. So these are just those same terms. What an heir is, that's your natural blood relatives that could claim your assets after you've died. Devise is the transfer of property by will upon death in your last will and testament. Devisor is the person who leaves you something in their will, and a devisee is the one who receives something in the will. Demise is a transfer of property by lease, not to be confused with the actual death term devise that it sounds very similar to, which is a transfer of property by will. Testate means you made a will. Intestate means you did not. Testator is a man who makes a will. Testatrix is a woman who makes a will. Probate is what we call that court proceeding that determines who the natural heirs are, and to confirm who the devisees are. It could be someone that you named in a will to get stuff that's not necessarily an heir of an estate are, no matter if you had a will or not, and what the assets after all debts have been paid are remaining, and then that will be distributed according to your wishes. An executor is a male, an executrix is a female. That's a trusted person, maybe a best friend, close relative, somebody you trust to ensure that all your final wishes are carried out as you've written them in your will. I know nobody wants to think about their demise. You know, we all think we're invincible and we'll be here forever, but we all need to make a will because nobody expects to die, you know, but you could step off a curb and get hit by a bus, you know, who the hell knows, you know, right? So you should have a will. And then name somebody as an executor or an executrix to make sure your final wishes are carried out. Otherwise, the court will appoint an administrator to do those duties, and they get 10% of it. All right. Descent and distribution is the laws of every state that determines who your heirs are and who has the right to claim inheritance after you die. We're going to actually go over that process. So if you guys have any questions, hold them off for just a minute because it's coming up soon. We're going to go over what New Jersey's laws of descent and distribution are. Now, escheat is when you die intestate, no heirs can be located or stepped forward. The property reverts to the state. They sell the property at an auction, and the money is held in a fund for 1 year. If nobody claims it, the state gets it. And then they piss it away however they see fit. Okay, a legacy is your personal assets that you've amassed during your lifetime, and the bequests are your wishes of who you wish to get them. Dower and courtesy rights are ancient rights in New Jersey that have been abolished. They abolished the creation of new dower or courtesy rights on May 28, 1980. Dower is the wife's rights in her husband's properties that he owned during his lifetime. And courtesy is a similar right the husband has in the wife's property. And the husband and wife have a right to all of the dower and courtesy rights, give you rights to all the properties your spouse owned during their lifetime while you're married. The good way to remember that is dower begins with a doe, and a doe is a deer, female deer, right? So dower is the wife's right, and courtesy, because men should be courteous to women, is a way to remember that that's the husband's right, the male's right. Don't even bring up gay marriage, because gay marriage was not a thing in May 28, 1980. Okay. It wasn't until Governor Christie signed it into law. Yes, the Republican Governor Christie signed gay marriage into law in New Jersey in, what was it, 2016 or something like that. Dower and courtesy rights were a new dower and courtesy right creation was abolished on May 28, 1980. They didn't abolish any existing rights. So anybody married before May 28, 1980 still has dower and courtesy rights as long as they're still married, you know. But anyone that was married after that date, May 28, 1980, you need to memorize the date as well as dower and courtesy. Dower is the wife's right, courtesy is the husband's right, but you also need to memorize that date. That's the date that New Jersey abolished the creation of new dower courtesy rights. After that date, if you got married, your spouse only has rights of joint possession for the primary marital residence. And any other property you own, if you own it on your own without your spouse's name on it, they have no interest in that property. You can leave it to anyone else you want. You don't have to leave it to your spouse. However, New Jersey does have a law that there's a minimum amount you need to leave to your spouse when you die in your will. You can't write your spouse out of your will. So if you do write your spouse out of the will, or you do leave them the lesser amount than what the state law's minimum is, the surviving spouse can say, nah, I'm going to go with the minimum that was required by law. 1/3 of the entire estate. Okay? So it's not half, but it's 1/3. It's half if it was before May 28, 1980. After May 28, 1980, 1/3. Okay? And missingmoney.com and unclaimedproperty.nj.gov are the sites where you could search your names and your relatives' names to see if there's any unclaimed assets or property that may be owed to you. Do you know if you have an FHA loan, a Federal Housing Administration, an FHA insured loan? If you pay off that loan and there was never a claim on the insurance policy because you paid it off, you know you're entitled to some of that insurance money back. Unclaimed property or missingmoney.com, it would be in there and you could see if money's owed to you. You know, I would say this is one of my first jobs as a kid, but that would be lying. It was sweeping up a bus station, local private bus station. But I was a go-getter as a kid. So, you know, I went and got all kinds of jobs in the back of some of these tech magazines when I was a kid. There was a thing there where you could become a skip tracer and you could learn all about it. Just cost you like $10 for the kit to learn about how to do it. And so I did that. And I actually became a skip tracer. I was too young to have any kind of real job, but I formed a business entity. And I actually had this as my job, tracking down people and letting them know that the government owed them money. Before there was any websites or database like this, you could mail into the federal government and on a floppy disk, you could pay for so many records of people in different areas and different criteria of what kind of people you're looking for that were owed money. And they would send it to you on a floppy disk, you know, those 5 1/4 floppy disks, if you're that old to remember, you know, so they sent you records, and then I used that along with the paperwork they sent me for contracts I could sign with people when I find them. I could reunite you with your money for a portion of that funds. Okay. And today they got these unclaimed property, missing money. You could do it yourself if you know about it, but most people don't know about this. So you could even still have skip tracing as a job today. But keep in mind, you need to check with each state's laws. I think New Jersey, it's still allowable. Some states, they don't allow it, you know, so you got to really go over it. Yeah, you could reunite people with their money in exchange for a portion of it. Look at that. Anyway, let's see how that transfer of property by will works. We already went over these terms. You're just highlighting them right now. But I'm going to start reading from this point over here when you guys are done doing all the highlights here. So highlight this on page 376. And also in the margin, I want you to write remembering legal terms, OR versus EE. And that's just, remember I told you, words that end in OR is the person who's giving whatever the root word is. Words that end in EE is the one that's receiving it, you know, like a lease. A lease is a contract where where an owner of property intentionally conveys their rights to their property to a tenant for a limited period of time to use it in exchange for rent. So the lessor is the one who gives the property. They give the lease. And the lessee is the one who receives that right. They receive the property for that limited period of time. Just giving you an example of how that works. You know, we've also went over devise. Transfer of property by will is known as devise. We have a devisor and a devisee. So we went over these terms already. So just do the highlights. And write this on the side. When you get done with it, let me know. And I'm going to read this, and then we're going to move on to the next page, which will talk about who has the right to inherit stuff and what the requirements are to make a will. So I'm just waiting on you guys. You got to let me know when you're done. Okay.
I'm all set.
All right. Is everybody done? Everybody good? All right. So here's a screenshot from chapter 7 where we actually have a graph that we're going to go over when we get to chapter 7 about remembering legal terminology OR versus EE and seeing who the players are. The root word is devise. That's when you leave a property in your will to somebody. The devisor is the one who's writing the will and leaving you their property. The devisee is the one that's receiving it. Grant. We grant our ownership of our real estate to someone when we sell it. So the grantor is the seller and the grantee is the buyer. The legacy is your personal property that you've amassed during your lifetime, and the legator is the one who's leaving it to you, and the legatee is the one who's getting it. A lease is that contract where an owner intentionally conveys their property and certain rights to that property to possess it for a limited period of time as defined in the lease. Remember, we got those bundle of sticks or the bundle of rights. You also have the right to keep others from entering your property. So when an owner gives you a lease, they're transferring, it's a conveyance in that they're giving you access to the property, but they're also transferring some of their rights. Like you could keep the owner of the property out of your apartment that you're renting from them. All right. It's their property, but they're transferring those rights to you while you're leasing it. They don't have the right to use the key just to walk in anytime they want. That would be trespassing, right? So the lessor is the landlord who gives you the rights. They give you the lease and the access to their property, and a lessee is the one who receives the lease. Mortgage is unique because if I ask people what a mortgage is, most people will tell me it's money. It's a loan to buy real estate. No, it's not. A loan is money to buy real estate. A mortgage is a promise to pay. So a mortgage is when a borrower promises to pay back the lender the money according to the terms in their agreement. If you lend me your money, I'll pay you back the money as we agreed. And if I fail to, the promise I'm making is if I fail to pay you back, you can foreclose on me to take back the property pledged as collateral for the loan, sell it at auction, and use the proceeds to pay off the debt. That's the promise to pay that the borrower's making. So it's called a mortgage loan, not just a mortgage. If you just say it a mortgage, most people will know what you're talking about. They're going to think of they're going to assume the loan, but technically it's incorrect. Mortgage is a promise to pay, and who makes so who is the mortgagor? It's the one who's giving the promise, and who's that?
The bank.
It's no.
Or the borrower.
The bank's giving the money. They're giving the loan. The borrower's in exchange giving their promise to pay. So the mortgagor is the borrower. That's the way to remember it. Sing it. Who is the mortgagor? The borrower. You remember it that way because you don't have to remember the whole storyline. You know, you just sing it. I like to keep it simple, stupid, so that you don't need to remember the whole process. Well, a mortgage is a promise to pay. The bank makes a loan. The borrower in exchange makes the promise. So the borrower's giving the promise to the bank. So they're the mortgagor. Okay. Instead of having to remember that whole thought process, just sing it. The mortgagor is the borrower. That's the great way to remember who the mortgagor is. You don't even need to think. You don't even need to remember that whole storyline. And then who is the mortgagee? Well, there is no thing that rhymes. It's the other guy. The lender is the mortgagee. Another way to remember this is the word mortgagor has 2 O's in it. Borrower has 2 O's in it. Mortgagee has 2 E's in it. Lender has 2 E's in it. There's another way. But
That was
for me,
that was a good one.
for me, singing it, I like to sing it. Yeah, don't you like my singing voice? The mortgagor is the borrower. Now you're going to be taking this exam. You think it's stupid now, but you're going to take this exam. You're going to see the word mortgagor there, and you're going to be like, mortgagor is the borrower. And you're going to be laughing. You're going to start laughing during your exam. I have so many students that tell me that they started laughing or chuckling during their exam when the word mortgagor came up because they remembered me singing it. The mortgagor is the borrower. Look at some of the reviews I have online. Some people, they even wrote it out. The mortgagor is the borrower. Like they remember that statement from class more than anything. All right. And you guys get the idea with the rest of them. Words that end in OR versus EE. But that mortgagor, they got the little asterisk there because it's opposite of what you probably think that it is. All right. Now, let's see. What are the legal requirements for you to make a will? Well, what is a will? Well, a person must be of legal age, 18 years of age or older, and sound mind when they execute the will. The drawing of the will must be a voluntary act, free of any undue influence by other people. Any person of sound mind who's 18 years of age or older can make a will, devising their real property and their personal property. All wills must be in writing to be valid. So in New Jersey, a video will, audio recorded wills, no bueno. It's not good. It's not valid. It's not legally enforceable. A will in New Jersey must be in writing. Okay. And the general rule is that a will must be witnessed by two people. A beneficiary in the will who's getting something out of the will can serve as a witness to the will in New Jersey. If the signatures of the witnesses are notarized within 2 days, probate proceedings can be fairly swift and simple. If you fully handwrite the will, meaning you don't type it or print it and then just sign it, if the entire document is handwritten, this is known as a holographic will. And they are legal in New Jersey and do not require any witnesses because the entire document is handwritten and signed by you. So it's a lot harder to forge an entire document than it is one signature. So this is why a holographic will doesn't require any witnesses to be legal. Under New Jersey estate planning law, holographic wills can be probated and will serve to ensure the testator's assets are bequeathed according to the testator's wishes. Remember, for real property acquired by a married deceased person before May 28, 1980, the date that New Jersey abolished the creation of any new dower or courtesy rights, the surviving spouse is still entitled to a life estate of 1/2 interest in all real estate they owned by the deceased, no matter what other provisions were made in the will. And
1/2 or 1/3?
1/2, because they're talking about persons that were married before May 28th, 1980, meaning that they have dower and courtesy rights. If you were married after May 28th, 1980, you do not have dower or courtesy rights. You only have the right of joint possession of the primary marital residence. And so you're entitled to 1/3 of the estate, not 1/2, because you don't have those dower and courtesy rights. So here, let's see, title to real estate and personal property of a person who dies intestate passes to their heirs under the descent statutes. The primary heirs of the deceased are their spouse or civil partner or domestic partner and close blood relatives. And when children have been legally adopted, most states consider them to be heirs of the adopting parents, but not heirs of the ancestors of the adopting parents. In most states, illegitimate children inherit from the mother, but they do not inherit from the father, unless he admitted parentage in writing or parentage has been established legally. If he adopts such child, that child inherits like an adopted child would from the adopted parent, but not the ancestors. Let's break that down for a second. You don't need to know any of this for exams. A lot of people just ask because they're curious about this stuff. So first of all, what is an illegitimate child? It's one where your parents were not married when you were born. Maybe they got married afterwards, but if they weren't married before you were born, you're considered an illegitimate child in the eyes of the law. So you could inherit from the mother, but do not inherit from the father unless it can be proven that he is the father in writing or parentage has been legally established in some other way, like with a blood test. Now, if he does adopt his natural blood relative child, that child inherits like an adopted child would. You could that adopted child can inherit from their parents, but not their ancestors. How screwed up is that? You can't claim to be a rightful heir of your father's brothers and uncles and grandfather, even though they're your blood relatives, simply because your parents were not married when you were born. So you were an illegitimate child. It's pretty effed up, huh? So, but keep in mind, they could always name you in their will. So what happens if you die and your parent, what happens if you die and you have no will? Well, every state has the laws of descent and distribution that dictate who gets your assets. Intestate real property distributed according to the laws, once again, of New Jersey. They only go into effect if you die without having a will. So let's start off here. The laws of descent come into effect only when the descendant leaves no will. A surviving spouse or partner become the sole heir if the descendant leaves no parents or children. If there is a child or children who are also the children of the surviving spouse, the spouse or partner receives the first $50,000 of your estate plus 1/2 of the remaining estate. The rest goes to the child or children. If the descendant leaves parents and the spouse but no children, the spouse or partner receives the first $50,000 plus 1/2 the remaining estate. The rest goes to the parent or parents. If there are children who are not the children of the surviving spouse, the spouse or partner receives half the estate and the child or children the other half. Where no spouse or partner survives, children become the sole natural heirs. And where there is neither surviving spouse nor children or children's own heirs, the estate goes first to the parents, and failing that, to brothers and sisters or their heirs. In default of any other natural heir, grandparents, aunts, uncles, and first cousins may be considered heirs. Beyond that point, the entire estate goes to the state of New Jersey by escheat. Okay, so how does escheat work? The state treasurer sells the property at a public sale, giving notice by publication in the local newspaper in your county and the paper in Trenton. So the local newspaper in Trenton and the newspaper in the county where the property is located. The proceeds of the sale are then held in a fund for 1 year. And if no claims are made within the year, the funds go to the state, and then your politicians get to use it however they see fit. Okay, so you may want to check and see if you have any funds laying out there from any relatives or yourself, possibly, using the state's page here, unclaimedproperty.nj.gov or missingmoney.com. New Jersey no longer participates in it, but you may still find some remnants in there, and from other states as well. So unclaimedproperty.nj.gov and missingmoney.com. And that concludes chapter 20. So let's do the key terms for chapter 20, and then we will go back and start chapter 6. Yes, because we jumped ahead after chapter 5 and did chapter 20 first. So I'm just trying to find the key terms to review here. And there's only one of them for this chapter. So without further ado, let's get it going. Before we do, I want you to write something next to number 5, where it says executor. I want you to put a slash and write executrix. Okay? Executrix. EXECUTRIX. Write that next to executor. Because executor is a man, executrix is a woman. Okay? So after you do that, go down to number 12, where it says testator, put a slash and write testatrix, TESTATRIX. Atrix. Testatrix. Okay. And then when you're done with that, go to letter L. And at the end of the line where it says one who can inherit, I want you to write blood relative after that. It's generally a blood relative. In some circumstances, it could be adopted children, but then it gets a little quirky, the laws on that. Okay, so now let's read it. Person named by the state to administer a descendant's will. Who is the person named by the state to administer a descendant's will?
An administrator.
An administrator. One is A. Court proceeding to establish validity of a will.
What proceedings?
Probate.
Probate, yeah.
Probate. 10 is B. Title acquired by usage.
Adverse possession.
Adverse possession. 2 is C. Person named in a will to administer a descendant's estate.
Devise.
Executor.
The executor or executrix, right? 5 is
Yep.
D. Well, we want to be fair. We want to put both the man and the woman there, right? We want to include them both since they're gendered terms, right? So executor and executrix, right? So 5 is D. A transfer of title without the grantor's consent. Without. What do we call it?
Involuntary alienation.
Involuntary alienation. 8 is E. Without a will. What do you call it if you didn't have a will?
Intestate.
Yeah.
Intestate. 7 is F. One who makes a will. What do you call the person who makes a will?
Testator.
The testator. 12, or testatrix. 12 is G. Correct. Document disposing of property after one's death.
Last will and testament.
Correct. 9 is H. Having made a will.
Testate.
Testate. 11 is I. Acquiring property by natural heirs. Acquiring a property by natural heirs is descent. 3 is J. Correct. One who receives real property through a will.
Devisee.
Devisee. 4 is K. One who can inherit, those blood relatives.
Heir. 6.
An heir. H-E-I-R. Heir. 6 is L. It's pronounced heir. The H is silent. Heir. Transfer of title with the grantor's consent.
Okay.
Voluntary alienation.
Yep. 13 is M, as in Mary. Voluntary alienation. All right. So, X that out. X that out. Dun, 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 dun. Let's go now to start chapter 6. Look at that. Now we're moving. Before we were doing a chapter a day, that was taking too long. Now we're starting the 3rd chapter.
We going
All right,
where?
let's see if we can get this chapter done today.
Where we going? Chapter what? 8.
Okay,
7.
so well, hold on a second. Let me first stop this recording. We're done with chapter 20.